Mr. Klassen?
No, just to good afternoon, honorable members, Speaker and Deputy Speaker. Just to clarify that the words in bold, the proposal is that they must be removed in brackets. And the underlined ones would be the new provision. So the second one is parties constituting a majority of NA members. If they say that they have an objection, that motion will not go. Thank you, Madam Speaker.
Thank you for that clarification. You can proceed, Honorable Lagude.
Proposed rule amendment to Rule 123, Sub-Rule 4. In addition, the subcommittee proposed to add Rule 123, Sub-Rule 4, subject to the conditions for a notice to be read. Once a motion is read in the House, any member may then object to the motion being proceeded with without notice, in which case such a motion will not be put for a decision, but will be considered to be a notice and submitted as such. On closing of
Order, Honorable Member, can I put the first matter that you have dealt with on motions without notice? There are two options that have been put. And as you have said earlier, that this is for adoption. So which one option are we adopting? Honorable Ndlozi?
Thanks, Speaker. We are for option 2.
Honorable Wessels?
Thank you, Honourable Speaker. We also support option 2.
Option 2 agreed to? Thank you. And propose rule amendment to Rule 123, subsection 4. Agreed to? Agreed. We now move to 5.2, which is closing doors during division. Honorable Lagude?
Thank you very much, Madam Speaker. On closing doors during a division, on the 20th of March 2024, the Rules Committee discussed a report from the Subcommittee on Physical Removal of Member from the Chamber relating to an incident of the 21st of February 2024, where several members of the Assembly where several members of the Assembly were physically removed from the chamber during a division. In this regard, the committee concurred with the removal of the members, but recommended that Rule 112, which deals with the barring of the doors when voting occurs, be re-examined in circumstances where disruptions occur. Following discussions, the subcommittee proposed the following rule amendment. Proposed rule amendment, Rule 112, when the doors have been barred, no member may enter or leave the chamber until the result of the division has been declared, except in the event the presiding officer has ordered a member to leave the chamber in terms of the rules, or a member to leave the chamber for any other reason to ensure the safety of the member. Then 3, in the event a member has voted but is ordered to leave the chamber in terms of Rule 112, Sub-Rule 2, before the results of the division has been declared, his or her vote shall be counted.
Thank you. I table the proposed amendment. Adopted, agreed to.
Agreed.
Can we move to 5.3 on Section 89 panel extension?
Section 89 panel extension. The National Assembly adopted rules to govern the application of Section 89 of the Constitution concerning the removal of the president on the 22nd of November 2018. The rules provide that inter alia, any independent panel established to conduct a preliminary assessment of the evidence presented by a member must conclude must conclude its assessment and report in 30 days. An independent panel was established in 2022. In the process of its assessment, the panel wrote to the Speaker with a request that the 30-day deadline be extended. The former Speaker thereafter applied Rule 6 to provide for such an extension. Rule 6 states that the Speaker may give a ruling or frame a rule in respect of any eventuality for which the rules and orders of the House do not provide, having due regard to the procedures, precedents, practices, and conventions developed by the House and on the basis of constitutional values and principles underpinning an open and democratic society. A rule framed by the Speaker remains in force until the House, based on a recommendation of the Rules Committee, has decided thereon. Owing to the fact that the decision by the former Speaker was taken in the 6th Parliament, the subcommittee recommended that the Rules Committee consider the following rule amendment. Rule 129G relating to period for independent panel to conduct its work. Rule 129G, sub-rule 3, notwithstanding Rule 129G, sub-rule 1, B, the Speaker may, at the request of the panel and on good cause shown, extend the time period stipulated in the said rule to such longer period as the Speaker may determine, which extended period may not exceed 90 days from the date of the appointment of the panel. In the event that the panel is B, in the event that the panel requests a further extension beyond the period determined by the Speaker, as contemplated in paragraph A, the Assembly may, on good cause shown, determine such an extended period.
Thank you. I now put the proposed amendment. Agreed? Agreed, Chair. So that's adopted. I'll now hand over to the Deputy Speaker.
Thank you, Speaker, and good afternoon to all the members. Honourable Dlakudi, you can proceed with the next one.
Questions to the executive and the regulation of ministerial responses. The rules permit members to pose both oral and written questions to the executive, the president, the deputy president, and the ministers.
Point of order, a little point of order.
Honourable Ndlozi, what is your point?
I
of order?
advise that the Speaker must stay here because we're going to establish a portfolio committee with the president. It's good that you are here so that you don't say you were not here. It's a very important matter. Can someone else go stand for you where you're going, Speaker?
Honourable Ndlozi, I think the Speaker has taken note, but she has made her decision. Right, please proceed, Honourable Dlakudi.
Ndlozi, ayaphazamisa man. The rules permit on questions to the executive and the regulation of ministerial responses. The rules permit members to pose both oral and written questions to the executive, the president, and the deputy president and ministers. Conversely, members of the cabinet must provide Parliament with full and regular reports on matters under their control. The Constitution also provides for all spheres of government and all organs of state within each sphere to exercise their powers and perform their functions in a manner that does not encroach on the geographical, functional, or institutional integrity of government in another sphere. On the 26th of June, 2024, the Rules Committee discussed the sequence of questions, the number of questions taken during a question time, and the option of extending the time allocated. And finally, concerns related to the nature of ministerial replies. Based on the discussions, the options for discussions were prepared. These options are attached on Annexure A. Based on the discussion of the challenges and options presented, members of the subcommittee made the following observation. The quality of executive replies. The rules of the assembly provide for questions to be on matters provide for the questions to be on matters the relevant minister is officially responsible for. That is Rule 134, Sub-Rule 5B. The Constitution also provides for members of the Cabinet to provide Parliament with full and regular reports on matters under their control. That is Section 9(2) subsection 3B. The Constitution also provides for all spheres of government and other organs of state within the sphere to exercise their powers and perform their functions in a manner that does not encroach on the geographical, functional, or institutional integrity of government in other sphere. That is Section 41, subsection 1G. The Rules Committee amplified these provisions in its decision on the 2nd of September 2022, that was 80 seat in November, on the 30th of November 2022, that is page 9, that related to the concurrent responsibilities between the province, national, and local sphere of government. Concerning the scope of the ministerial responsibilities and their answerability on functional areas of concurrent responsibility between the different spheres of government and how this impacted on the timelines of replies. Questions to the executive should take into account their respective competences. The National Assembly, in establishing the system to monitor delayed replies to questions on the 2nd of September 2022, also determined that when ministers replies to question, the speaker may not dictate the form in which a minister should reply, but they are expected to answer the specific points contained in a question. That was 80 seat on the 25th of August 2021. Reprint page 2. In terms of Rule 7, members must comply with any guidelines and directives of the Rules Committee. Accordingly, this directive is binding on executive, and the Rules Committee should affirm this position. Further, the subcommittee recommended that political parties should monitor the replies they received to parliamentary questions until the end of this annual session and write to the speaker in respect of every reply that, in their view, fell short on providing a qualitative response. The party, in its communication to the speaker, outline how the minister failed to provide a quality reply. Number 3, the speaker will compile and refer a report to the subcommittee on the review of the Assembly Rules meeting in 2025. The subcommittee will then consider the concerns raised by parties. The subcommittee may then propose a further period of monitoring and reporting, depending on whether the core concerns were covered or not. The subcommittee will then consider protocols and guidelines on the executive replies, these will then put to the Rules Committee for further consideration and adoption. Optimizing time for questions. It was desirable that as many ministers as possible answer oral questions in the House on a question day without detracting from the prerogative of parties to prioritize their questions. While the possibility of interpellation could be explored further, the current arrangement of supplementary questions could be revised, for an example, to allow the questioner a second opportunity to pose a supplementary questions. The time for ministerial responses to an initial question could be reduced from 4 to 3 minutes to reach more original questions. The number of supplementary questions could also be reduced. In the context and specifically on optimizing time for questions, the Rules Committee is requested to note the observations made and allow the subcommittee time to explore improvements. Thank you.
Thank you, Honourable Dlakude. Honourable Michalakis.
Thank you, Honourable Chairperson. Under optimizing time for questions, I do not agree with point 2 there. I would like to propose that this committee task the subcommittee with coming up with rules for interpellations, and that parties should be afforded the opportunity to make submissions in this regard. Thank you.
Honourable members, we now have a proposal here. I'm going to allow for that to be discussed. Honourable Ndlozi.
Thanks, Deputy Speaker. We 100% support the resolution that the Rules Committee should refer should agree that there must be a development of a rule for interpolation. Because we just want to say that the entire recommended changes will not improve the quality of replies. But the system of interpolation is the only hope we have. That's the first thing. So we support that proposal. In terms of point number we wanted a rule, a on-the-spot rule. So there is a rule in relation to debates in which if we're debating a specific subject, I can raise a point of order if the person that is debating goes out of topic, and the speaker or the chairperson on the spot can say to the person, stick to the topic. We asked for a development of a rule in that regard during questions and answers, whether of the entire executive, that if a person that is answering ventures out of topic or does not answer the question properly, on the spot, the speaker doesn't have to say you must answer in a specific way. They can at least say, in terms of the original answer, the original question, you are not answering the question because you have ventured out. So we would move that the Rules Committee refer that particular development of a rule back to the Sub-Rules Committee. Thanks very much.
Thank you, Honourable Ndlozi.